Hey, Florida Family Law Complex Parenting student. We are back. We are here with two people that are familiar to you. We have Rebecca Cantor. I'm pointing up because of the way it's showing on my screen, but that might not make sense for you. But we have Rebecca Cantor, who joined us for our inaugural video of how to prepare for a deposition. And today we're also joined by Patrick McGeehan, who came to our class before to talk about discovery. And so today we're going to have a conversation with all of you about how do you prepare your client to be deposed? How do you prepare with your client for mediation? How do you prepare for a hearing? How do you prepare your client to meet with the guardian ad litem? So let's get started. So I think what we'll first do is I'm going to say that the first thing you want to do when your client is set for deposition, you need to coordinate that date with them. You need to make sure they get the notice. You need to make sure they know where to be and when, and you need to set up a meeting with them. Now, what I tend to do is also I send them a letter, which one is to inform them, but two, it's a CYA letter, if any of you have heard that expression, because you don't want your client to later say, well, you never told me not to lie during my deposition. And then you're like, wait a minute, I sent you a letter, and that was like in the first paragraph. It said, don't lie. So what I want to do is first I will ask Rebecca how she prepares her clients when they are going to be the one in the hot seat answering questions. And then we'll have Patrick talk about what his method is with his clients.
Well, thank you. It's nice to be back, and I'm still in my backyard, which is a lovely place to be. So the first thing that I counsel my clients about, I sort of do it as a bookend in the meeting, because I do it when we start the meeting and I do it at the end of the meeting because I think it's important. And I even remind them the morning of depo as well, is that the person who is asking them the questions is not their friend. And while the style of the deposing attorney might be very conciliatory, very kind, very let's all get along, let's be friendly, a reasonable tone of voice, they are not your friend. They're there to get information out of you that you don't necessarily want to share. So I remind my clients most strongly of that first. And I also remind the clients the way that I'm sure your students were reminded on the first day of law school, that I don't know is a perfectly valid answer to a question. If you do not know the information, do not guess. If you don't have access to the information, say you don't have access to the information. And I also try to remind my clients that whenever a question is asked of them, and this is true in deposition as well as in front of the judge, to take a nice pause before they consider their answer so that they can make sure they understood the question, and to give me room as their attorney to make an objection if one is necessary. So I remind my clients about pacing. It should be a much slower conversation. They should take a beat. They should be slow, be deliberate, and don't allow it to become a conversation. It's not a conversation. So that's my first piece of advice that I give the clients when we're preparing for deposition. And then the next thing I do is I try to think about what are the kinds of questions my client's going to be asked, and I review that information. And I try to see if there are holes, if there's some inconsistencies, and what would be the strategy for describing them, explaining them, and understanding them that we would give to the other attorney or not, right? Part of the strategy in deposition is not to give the other side your whole hand. So your client may have a very valid inconsistency on his financial affidavits as compared to his tax returns, let's say, and there's probably an excellent reason for it. We will assume our clients are upstanding citizens, but that doesn't mean we get to tell opposing counsel why that is. If opposing counsel doesn't ask the right questions, they're not entitled to the answers. And so, make opposing counsel do their job is also part of what I think about when I think about strategizing in deposition.
For sure. And I think a good tip is, and it depends how much money there is in the case. Sometimes you just need to bring your client in and talk to them. And sometimes if there's a great deal of money or a great deal of money at stake, you can actually prepare an agenda for your client. Here are the topics that I think they're going to ask you questions about. Here are the exhibits that I think they're going to have you look at. And even though you've been contemporaneously giving everything to your client as it's come in, any letter or discovery document or pleading, you can prepare a little binder for them and say, here's the things that I think they're going to ask you about. But it's one of those things where you can't do it in every case. The money's not always there. But if the money is there, it is one of those things that I think is helpful, is to have that meeting with that agenda, give your client some homework. So Patrick, what is your strategy for getting your client ready for deposition? And you come at it from a different perspective because you are former homicide detective, sort of an expert interrogator.
I mean, I do everything that Rebecca does, and I'll just add to that. All those were good points, but I do it a little bit differently because I've given depositions before as a police officer, so I'm very familiar with that arena. What I'll do is when we schedule depositions, usually we'll have them in some type of sequential order where, you know, my person's deposition, then the opposing party or witness or whatever, and whatever that order is leading up to that, when I do the preparation, I'll do an outline that I am going to use to ask questions. And then I will share that with my client. And then I'll also do an outline of a deposition if I was going to depose my client. And I'll go over that with them in the meeting. I always tell my clients to keep a journal of everything that goes on in their life related to the case. Most of them don't, but some of them actually do. And I tell them to go through all the pleadings, and I'll send them a zip file of all the pleadings to date. I'll go, make sure you know your pleadings front and back. Make sure you review your financial affidavit. Make sure you review any requests to produce that we sent out or that we received. I give them a bunch of homework to do. And then after that, then I'll schedule that meeting and say, okay, here is what they're going to ask you. Here are the topics that are at issue. When you sit for a deposition, sometimes attorneys speak really quickly during their depositions because they're going by written questions or outlines and they kind of zip them off. I tell them, hey, if the question comes at you too fast or you don't understand it, make sure that you tell them, I don't understand it. Can you rephrase it in another way? I didn't get the question, or something to clarify that. Because if you go on and go ahead and answer and that court reporter takes down that question and you didn't understand the question, but you gave an answer that you thought was the answer, that's going to cause problems later on. And of course, I tell them to always be truthful, always be upfront. And I tell them to be as short as possible to answer the question fully. If the question can be answered with a yes or no, give a yes or no. If there needs further explanation, give a yes or no, but, or yes or no in addition to, and then go on with your explanation. But keep it slow. Don't make it a back and forth conversation, and, you know, try to not give them answers that open up other issues which haven't been identified yet. You know, only answer the question that you're being asked and don't expound into other issues, because I've seen in depositions before when and a lot of times I see it in criminal cases more so than in family cases, but I do see it in family cases where you'll ask a very simple question of a witness and they'll come back with a 20-minute answer, which opens the door to all these other issues that you didn't even realize.
No, for sure.
Yeah.
So, and you know, you also want to remind your clients, like, listen, like, don't tell jokes, because it does, you know, anybody who's gotten into a fight with somebody in like a text message and they go, well, tone is hard to read in a text message. Well, guess what? Tone is also hard to read in a transcript if somebody else is writing down everything you say. It's not a screenplay where it's like says in a snarky tone. So you have to remind your clients, like, don't tell any jokes, don't lose your temper. And, you know, like what they both said, just give the information that you know. Don't like volunteer information, don't launch into some big story, because what happens when you actually get to the deposition? I would ask either of you, you know, once you're in the deposition, it's sort of like in sports, there are sports where the coach has like a headset, right? Like in football, everybody's like mic'd up and you can like tell people what to do, but in tennis, you can't even like give a sign, right? And so where do lawyers fall? on the spectrum of coaching your client or giving advice to your client during a deposition?
Well, I'm very careful and not to call it coaching your client, because I don't coach my clients. I tell them basically what to expect and what can be shot in front of them, because I don't want them to come back and go, hey, he coached me to say that if something comes up. So I don't use that terminology about coaching. I just sit them down and go, listen, I'm going to familiarize you with what a deposition is and what they're likely to ask you. And, I tell them, I go, I can't help you while I can't help you with the answer or give you the answer or tell you what to say, other than if there's an objection to a privilege or something like that, a Fifth Amendment privilege or something.
Right.
And,
they're very much on their own to a certain extent.
Yeah.
Once the question has, so let's say I'm the lawyer, you're the deponent, and Rebecca, I'm the lawyer for you, you're being deposed, and Rebecca's the one asking the question. If she asks a question, what are you allowed to do with me, your lawyer?
Wait, I got a question. Tell me about
Yes.
how you beat your child.
Objection to the form.
Yeah, it's always objection to the form.
No predicate, it's inflammatory, it's argumentative, but the question still has to be answered, right? So Rebecca, would you then have the choice to reframe your question or say, listen, go ahead and answer the question?
Well, actually, there may be a Fifth Amendment privilege there too.
Mm-hmm.
So, right, I could maybe rephrase my question. I say, I apologize for my tone. Tell me a little bit about how you discipline your child.
And then
exactly.
and then Patrick, you would have to answer that question.
Right. Well, I would say, if you ask me the beat me question, the answer would be
the discipline question. You can do both, but
let me address.
I objected to her question. I'm your lawyer.
Right.
I objected to her question. She has chosen to rephrase the question to say, how do you discipline your child?
But I would jump on that. How do you beat your kid, or how often do you beat your kid? And the answer would be, I never beat my kid. And then she follows up, well, how do you discipline your child? And then I would give the answer to how the child is disciplined. But I wouldn't even go there. I wouldn't let her go there. You have a lot of people, when they go to depositions, they become completely defensive, but there are offensive plays that you can launch in a deposition. And you can, as the attorney, attorneys are skilled at asking questions and seeking information and doing depositions. But what I learned in being deposed is that there's times when you can steer the attorney just as much as he can steer you. And in that line of questioning, how do you beat your child is a perfect example of how you do it. I don't beat my child. I've never beat my child.
But what if that's not the case, right? What
well,
if
you're
that's
not going to go.
Well, is that you believe in corporal punishment, and
corporal punishment and beating your child is two different things. Corporal punishment is permissible. Beating your child gives the impression that you're abusing your child. So the answer would still be, I don't beat my child.
And then again, it falls onto the attorney to ask the right questions. If I'm only asking about how Patrick beats his child, which, by the way, everyone, never happened. He doesn't. He's a great dad. But if I'm only asking Patrick about how he beats his child and I don't change my tactic, Patrick, as the deponent, has done an incredibly good job of getting me away from the topic. I can't pursue that line of questioning, and so I'm going to lose the fact that what I really want to get at is he broke the skin, he left marks, it happens when the child doesn't eat broccoli, or any of the other really specific details that would be helpful to the case. He's moved me way off course, and I, as the attorney, have lost track. And so it's the responsibility of good questioning attorneys to really know what it is they're trying to get out, which goes back to the prior lecture that you and I worked on yesterday.
Yeah, it's a good way to remove the shock value from the case. But something else that a lot of people don't know is, if you get these offensive questions in a deposition, you can request, as the deponent, you can request that the question be certified. And I've seen that done in depositions.
Tell my students what that means.
Where if you request the question to be certified, you have to have, your attorney does a motion for the judge to review the question and see if it should be answered. And we've used that in several family cases, but a lot in criminal cases. Police officers will use that a lot when they're being deposed.
No, we see it quite a bit in family law.
Yeah.
We see it quite a bit in family law as well.
But I've had where my client's been deposed in a case, and the attorney is more interested about what he's doing intimately with the new girlfriend than he is about the financials of the parties and the relationship for the parties. And they try to lead your client down that yellow brick road. For what reason, I'm not really sure. Sometimes I just think it's, because the client's demanding to know, his client's demanding to know, and they're going down that road, and that can open up, all kinds of ethical problems for you in addition to.
Yes. But I think in terms of preparing your client for a depo is most of it has to be done in advance, because once you're in the depo, you have limited ways that you can protect your client. You can object to the question. Most of the time they still have to answer. There are very rare instances that we had mentioned yesterday, like attorney-client privilege, work product protection, or sometimes Fifth Amendment, where they don't actually have to answer. But it also then requires having sometimes a very quick thinking client, which you are not always going to be blessed with. More often than not, they're going to be pretty terrible. No matter, no matter how much you prepare them, some people just don't do well in the pressure of a deposition, and even worse in court. So let's move on from a deposition to, go ahead.
I mean, I've actually had I had one client that got so sick in a deposition because of the stress, she started barfing. So, I mean, some people just over stress about it.
I had a client faint in deposition. Yeah.
And another thing, what Rebecca said, or Kira said about the tone in a deposition is like a text message. That's why I started doing, about 1.5 years ago in domestic violence cases, I started doing video depositions. So you can get some of that tone in there. And it's been very beneficial.
Yeah, so, and a practice tip is you always want to clear it with your client, because there's an additional cost to have a videographer there and to have the video produced. And that means also if you want to have it in court, you're going to need to have that technology available. But in your notice of taking deposition, if it's a video deposition, you absolutely have to disclose that it's a video deposition and who is the agency that's doing the video. But it is something to be used. We've done it to great effect in several cases. I can think of one where the husband made about $200,000 a year. My client, she was the wife, she made about $1 million a year, and he wanted alimony. And so there's this sort of big question of, does somebody who makes $200,000 a year really need alimony? And so the question posed to him in the video deposition was, well, how much do you need? And he leans back all cocky and spreads his arms out. He's like, as much as I can get. And his lawyer's head just went flat down on the conference room table, because she was like, you idiot, right? You cocky jerk. How did you just destroy your whole alimony case in, this entitlement? And obviously then the settlement included 0 alimony. Right. So, that's one thing you're going to have to prepare your client for, is a deposition. Another is mediation. And the odds of that happening are actually higher, because depositions are not taken in every single case. A lot of times people will try to settle a case first before they do the litigation. A lot of times what you'll see actually is a mediation set with deposition set for the week or two after, because what you want to do is you don't want somebody to leave a mediation with nothing at stake, right? Because a lot of people will just walk out of a mediation because there's nothing coming up, there's no pressure, they can just leave. But if they're like, oh shoot, if I leave this mediation without a settlement, and that means next week I have to sit for my deposition, which really strikes fear in a lot of people. I don't think they realize how boring depositions are. Or, I have to go to court, or, whatever it is. So you're definitely going to be in mediation. Unless you have a case of domestic violence where there hasn't been an order put into place allowing the mediation to go forward, mediation is required in 100% of your cases before you can get a trial date. So while there's some cases that may settle on their own without mediation, you're going to be doing probably a lot more mediations than depositions in a case that isn't super litigious. You might not have any depositions, you'll definitely have mediation. And so the question is, how do you prepare your client for mediation. So like, I know for me, well, for a deposition, I bring my client in and meet with them in advance and strategize. For mediation, I tend to just talk to them on the phone. Because to me, it's all about explaining the process of mediation, explaining to them, listen, like, it's not very formal. Like, bring a book, bring a sweater. It's gonna be cold. Bring some snacks in case you don't like what they have, and really explain it. We're gonna be sitting in one room. Your spouse and their lawyer or law clerk or law team will be sitting in the other room. And the mediator is going to go back and forth to try to facilitate resolution. And sometimes the mediator may say, I want to meet with just the lawyers, or I want to meet with just the parties. But for the most part, you're sort of divided. And so it's a pretty informal process. So what I do is a couple of things to prepare for mediation. In a parenting case, I will work out a parenting plan with my client, because parenting plans are very personal. There's like legal things that you want to have in there, but so much of what's in a parenting plan that we've gone over this semester is very personal to that family's circumstances, depending on where do extended relatives live, where does extended family live, what was sort of like the custom, did kids go to boarding school, did kids spend their whole summer abroad with a grandparent who lives abroad, how close do the parents live? And so I always try to sit with my client and work out a parenting plan so that we're walking into mediation with a parenting plan. In more contested cases, and it kind of depends again on your client's financial resources, we will do a mediation statement where we will do a confidential mediation statement to the mediator that says, like, here's the background, our spin on it, here are the issues, here's really where we're looking to settle, here's our proposed parenting plan, or here's the financial affidavits, or here's the settlement letter we sent to the other side. I don't do it in every mediation, I do it in some, but it's also a really good way to crystallize with your client their expectations. So I'm going to throw it to Rebecca, because she and I, in preparation for this video, had talked a little bit about setting client expectations.
So it's interesting that you do your conversations about mediation with your client, because that's one of the ones that I feel like is really important to do in person. And so that's the sort of thing that I really want to see my clients for. And I want to sit down with them. At least my experience is that my clients really want to hammer through the details of what it is they want. And part of what I try to do in that meeting is refine for them what it is we really might reasonably expect to get, right? So your client who made $200,000 a year and wanted as much alimony as possible, right? I feel like it works so much better for me if I sit with my client face to face and go, seriously, buddy, you make $200,000 a year, let's be reasonable. And I can go sort of line by line on the issues that we have and our pleadings about financial stuff always, about children's stuff always, and say kind of where's your deal breaker on this? I know what I'm going to lead with. I'm going to lead with, you want $1 million a year in alimony. I know that's where we're starting, but tell me where we're walking. What's the point at which you go, forget that, whatever the judge says, I'm done. So I know where that is, because that'll help me drive the process to the extent that I can, level it out with the mediator if needs be, or not, but at least we kind of know where we are. And I think it also helps the client, if the case settles, feel good about the mediation, right? There's this saying among mediators that if everybody walks out unhappy, it was a good mediation. And I think it's a crock. I think if everybody walks out of mediation feeling crappy, it was a crappy mediation. If you know what your bottom line is, if your client knows what his bottom line is, and he comes out ahead of his bottom line, he came out with a W. And you should stress that. And so he feels better about the mediation. So I really like to sit down and talk with the clients about the nitty gritties and the nuts and the bolts and what are your expectations and what do we think we can get? Because I feel like they feel a lot more prepared when we get there. Deposition is scary, mediation is scary, court hearings are scary. We do it every single day. For us, it's nothing. But for our clients, this is their lives. And there is so much on the line and it's terrifying. And so, yes, I can downplay it and say, yes, wear jeans, bring snacks, bring a sweater, we'll hang out, it'll be cool. we'll show each other pictures of our grandchildren or whatever. But for them, it's still a very formal, really important process. And I want to honor that. And so I absolutely meet with them first, face to face, because I want to have them know that I feel the gravitas of the situation as well.
Yeah, you and I have a totally different perspective. The last mediation I went to, I told my client, do we need to meet? I'm like, we do not need to meet, but we can talk. And we spent about 2 hours on the phone because there were multiple properties, multiple brokerage accounts. They had a very interesting relationship because it was an LGBT relationship where they were together for a very long time, but the marriage was much shorter. We were trying to figure out, you know, what perspective are we coming from, the like, we're not going to use homophobic laws to our advantage. You know, for the other side, it was the more money party. But I still was like, I'm still not a like, let's all come in and sit down and whatnot. But you're making me feel a little guilty, which, but I'm like, we could do it on the phone. Because my thing is, if they're going to start in our room first, we have formulated on the phone our offer. If they're going to start in the other room, we might have an hour or an hour and a half just like hanging out, doing nothing, where we can do that work and we can have those conversations. But maybe I need to be a little bit more attentive to my clients' emotional needs, as opposed to being like, we're gonna have all the time. We're gonna be sick of each other by the time it's done. So Patrick, are you the tiebreaker? I feel like you probably meet with them, and I'm like the only one who doesn't.
I'll meet with them sometime, but I basically break it down into a two-tiered preparation process. Like a week before or 2 weeks before the mediation, I'll ask them, I go, listen, send me a list of your goals, that if you could get what you wanted in this particular case, what would it be, related to all the issues in the case. And then, you know, maybe a week later, I'll schedule a meeting with them. And sometimes, depending upon who the client is and what their personality is, and, you know, how scared they are or whatever, how much hand-holding they need, I'll do an in-person meeting. Otherwise, I'll do it on the phone. And at that second intersection, I'll go through and I'll manage their expectations. You know, if they want, you know, $5,000 a month in child support and $15,000 a month in alimony, I'll go, listen, you're probably not going to get the $5,000 based on the financial affidavits. Here's what you're more likely to get in alimony. Here's the calculation for child support based on the finances. And then, you know, I'll tell them, go back, reevaluate your wish list, and then give me another list that is what is acceptable to you. What will, when you walk out of that mediation, what will make you say, I did okay, I survived, I did well, and send me that. And then we'll look at what is in between those two extremes. And the most important part about it is verify who is buying lunch and, if required, dinner at the mediation, which is usually the mediator.
Yeah.
But yeah, I mean, it's a similar process.
Rebecca and I are both certified mediators. And so if it's in my office, I do coffee, I do lunch. I'm always shocked at like the caliber of menus my office hands out. Like, really? Like, this is a very nice place. And you know, you always kind of roll your eyes when somebody brought like their associate, their law clerk, like the corporate accountant, and all of a sudden you're like buying lunch for like 8 people at a restaurant. You don't normally do that, but it's you know, you got to keep people fed. If I do it in somebody else's office, I will always offer, but Miami tends to be a pretty hospitable place. And so often the lawyers will be like, no, like we have it. And then there's always like really weird, I was like once in a mediation and I was the mediator and they were like, well, we're going to buy you lunch, but we're just going to give a menu to the other room and like they can order what they want and pay for it. And it's like, it's weird. I don't know. I was a mediator a couple of weeks ago and it was all parenting issues. We're mediating again on the financials, but I walked in and the lawyer had all these bagels and cream cheese and I was so happy. And so it is something to think about. But sometimes, yeah, you won't get fed. I was in a mediation a couple of weeks ago. I was not the mediator and it was great because there was like food and there was coffee and there were snacks and cookies. But I was like in a windowless conference room for 10 hours. And so you can, you know, if sometimes I'll tell my clients, like, just go for a walk, right? Because it's hard when you're in a mediation. And you don't see the sun for 10 hours and they're making all these big decisions. Any other, so another thing I think, especially in parenting cases, as a tip for your clients is for them to also like make a list, like what Patrick said, like make like your big wish list, but also make a list of like those little tiny things that lawyers don't care about and judges don't care about, but your clients might really care about. So like I had a client who it was very important to her that she be the one to take their child to get her ears pierced and to pick out the earrings. And she had like a specific store. I think she wanted to get them from Tiffany's. And it was just really important to her. Like a judge isn't going to care. There's no legal basis for it, but it was important to her. And it was important enough that she wanted it in her agreement so that it wasn't a conflict down the road where he wanted to be there too, or he just went ahead and did it. So those are the sorts of things like you don't know, right? You could be doing this. We've all been doing this for like, well, Rebecca and I were doing this for 20 years. Patrick, this is a second career for him. So he's been doing it less. But you can't predict that that's like going to be an issue that you need to discuss with your client. So any other tips on preparing your client for mediation before we jump to preparing your client for a hearing?
That's good.
Okay. I think I would just add one thing, which is make sure your client understands that mediation, if they settle, that's it. There's no, we get to go back to court or there's like another fight to be had. If you reach an agreement in mediation, you're done. Unless it's like, you know, there's exceptions, you can reach partial agreements and whatnot. Because I think what we all sort of experience in mediation is cases don't settle necessarily because the settlement is reasonable. It settles because the people are in an emotional place where they can accept that the case is going to end. And so sometimes you come into a mediation where people kind of will take a worse deal than maybe they were offered 6 months ago because they just want to be done already. And sometimes you have people who are like so unreasonable that even if they're offered a good deal, they're just not ready. So you just need to make your client understand this is the parenting plan. This is the settlement agreement. These are going to be adopted by a court as its order. And this is it. We're done. I'm having that issue now. We had a trial set. We had a mediation scheduled. This was all like around Christmas, Hanukkah. And we had the mediation like the day before Noche Buena. We went into like, I think like 11 p.m. at night. It was exhausting. People kept talking about ordering dinner. Nobody freaking did. I was like, isn't there like a great Cuban restaurant around here? Like, why is nobody on board with me with like ordering food? And then of course, you know, you're like, am I like, you know, the only hungry one around here? But we then had to like reconvene. Like we did Noche Buena, everybody did Christmas. And then like the day after Christmas, we're all back at it negotiating. And we were using my template of a parenting plan that I had prepared with my client in advance of mediation. We had actually prepared it and sent it to the guardian before her report was due to say, hey, this is like what we want. And it was funny because my initial draft was really draconian. My client was like, wow, like this is really strict and kind of like a lot. And she made me be the more reasonable one, whereas I was like, your wife is crazy. Which, you know, it's, the problems continue. So what happened is they ultimately reach a parenting plan. They meet with the guardian. We reach the parenting plan. And the woman's lawyer, the other woman's lawyer, gets out of the case because she's like, for whatever her reasons are, I can only guess as to why she wouldn't want to deal with her client anymore. And now we have this new lawyer coming in, and I have to talk to her today after we do this to be like, here's the like 30 things that your client has violated in the parenting plan, because her client is under the impression that the parenting plan is not an order. Even though the court has adopted it as its order, there is a final judgment. She's like, it's an advisory document. These are suggestions. Or she'll be like, I didn't agree to that. That wasn't negotiated. We didn't talk about that. And it was like, first of all, if you do 2 days of mediation from morning till night, it was probably talked about. But you just need to make sure that they understand this is it. When you're in mediation, this is it. There's no going to court to get the big, your day in court. Oh, but sometimes mediation doesn't work. Sometimes you go to court before mediation, potentially on a temporary issue, a temporary parenting plan, or a motion for a guardian ad litem. You know, there's some non-evidentiary stuff. There's some evidentiary stuff where you could go to court, or you're having a final hearing, right? The mediation didn't work. You need to have a trial. Usually in cases where either one or both people are completely unreasonable, because reasonable people can sort of always reach an agreement, or the stakes are really high, like a relocation case, like a case where we're dealing with sole parental responsibility or supervised time sharing. And so then you're going to court and you can't testify for your client as much as you'd like to. You have to put this person on the stands with the judge and all the courtroom personnel. So how do you prepare your client for that? Rebecca and then Patrick.
Is this where I get to tell my story?
This is, oh, about Coolio or Busta Rhymes? What was, I have a text. I have
Yeah. So
a rap artist from
right.
our generation. Yes.
So for those of you who don't know who Coolio is, I recommend you Google Gangsta Paradise. In 2001, my first job out of law school, I was working at Legal Aid. And I had a client that we all affectionately referred to as Coolio because he had that hairstyle. So that's why we called him Coolio. And he was a really great guy and he was getting divorced. And this was way back before parenting plans, when people had primary residential parent and secondary residential parent and liberal and reasonable visitation. And, you know, it was kind of fast and loose. And so my client's children's names, I am not making this up, were Queen and Princess. Did not believe him until I saw the birth certificates.
Does that give one an inferiority complex when one is queen and one is princess? I would think so. I think you're cursing your children from day one with that, but go ahead.
I don't know. So his
Patrick thinks you're ridiculous.
his children were named Queen and Princess. And this was a gentleman that had no money. He was a legal aid client and his budget was so tight it squeaked. He cut hair at the swap shop. That was his profession. It was really just, he just didn't have a nickel. But what he did have was Coolio's hairstyle with the teeny tiny little braids sticking up all over. And he had a mouthful of gold and he had tattoos from his wrists all the way up to the top of his neck and a bazillion chains and Santeria chains and things that I didn't understand. And I understand more now, but I certainly didn't understand then.
I'm not into chains, but I'm very much into the tattoos.
And he read, right, looking at him coming down the hall, he read as a thug. He read as bad news. He read as not a good parent, right? That was sort of your first impression. And so when it was time to go to trial, and in the meantime, right, his soon-to-be ex-wife pretty much had the kids, didn't let him ever see the kids, didn't answer his calls. He never had access to his children. And the one thing he wanted more than anything in the world was for his kids to live with him. And, you know, he couldn't get them. He couldn't even get to see them. It was, you know, really terrible. I think mom was a no-show to mediation and we ultimately went to trial, right? This isn't legal aid. There is zero budget. There were no depositions. There's no evidentiary. There's very little discovery. You just gotta like shoot from the hip. So I sat down with him and I said, so listen, our magistrate is a nice Jewish lady and I can relate to that because I'm a nice Jewish lady and she's kind of like my grandma and she's gonna judge you. And so we need to really think about how you're gonna look. And so I said to him, when we get to trial, there should be no chains. I cannot see a tattoo. You must wear a button-down shirt. I can't see any gold in your mouth. You have to change your hair completely. So that my first thing that I did with preparing my client was about appearance. That was the first thing. The second thing I said to him was, you are only allowed to look at two people the entire time we're in front of the judge. You can look at the judge and you can look at me. You may not look at your ex. You may not look at your ex's attorney if she has one. The only two people you can look at are the judge and me. You look at me when I ask you questions and you look at the judge for answers. And the judge in this case is God. You call her your honor, you call her ma'am. You stand up when she stands up, you sit down when she sits down, and you treat her with the most respect you ever treated anyone in your life. So I talked about behavior. And the other thing I said to him was, and lawyers do this all the time, I'm gonna give you a piece of paper and a pen. If you have questions, concerns, or problems, you're gonna write them down and tell me about it. That's fine, we're gonna communicate, it's okay. But otherwise, if you're not looking at me or the judge, your eyes are on that paper. You have to look at it. And I wrote on the paper, look here, with a little star. So there was something for him to look at. So we arrived to court I arrived to court and I walked past my client, did not recognize him. He had done everything I had suggested to the letter. He was in a button-down shirt, the gold was gone, the hair was braided appropriately, I couldn't see a tattoo, he was ready to go. I gave him a piece of paper, we walked into the courtroom, the judge stood up, he stood up, the judge sat down, he sat down, he kept his eyes on the paper, he just did everything I asked him to do. Yes, ma'am, thank you, ma'am, please, just exemplary, which told me a lot about how much he really wanted his children, right? How very motivated he was to have access to his children, have his children come to live with him. His ex showed up. She was wearing a tube sock, could have been a dress, not really sure. It was not appropriate. Did not have an attorney. Big, huge sort of fluorescent green and pink hoop earrings. And she lost her mind on us, right? Yelled at him, yelled at me. And he just looked at me and I pointed to the paper and he put his eyes back down on the paper. We just sat there quietly and let her rant. And then of course the outcome was inevitable, right? The judge awarded that my client should be the primary residential parent with such access and time sharing as he thought was appropriate for his ex. And later that day, the children went to his house. And that was that. But it really had so much to do with client, preparation, because litigation is theater and you have to know that. I think of it that way. I think of going to court as theater. You have to think about your costume. You have to think about your set design. You have to think about your audience, because the person making decisions is really just going to look two-dimensionally. And so you have to really think about what's your two dimensions. And so a lot of that is with client prep as well.
Yeah, I think one of the most disgusting things I've ever done as court is have my client spit his gum into because you're like, because you don't think of everything. And you kind of look over and you're like, is my client sitting there and this was like a custody case over 3 kids. And it was like, just give me the gum. But I have had friends get thrown up on. So I will say that I have been spared from some of the most, my friend told me once, the opposing counsel, her client threw up and she went to catch it in her hands, which is such a parent move. And then just froze and apparently got in her hair. And the judge was like, do you want to borrow my scrunchie to before you go? I mean, it's just an awful situation. So you can't predict everything that's going to happen, but you can account for some stuff. So Patrick, how do you prepare your clients for a hearing?
I do it, I go over with them something similar to what I do for a deposition preparation or a hearing preparation, but I give them two legal pads. One legal pad is to write questions on, and one legal pad is to take notes on. So I tell them, I go, listen, if you're not writing questions to me about something, you need to be taking notes. And if you're doing neither, you need to be looking at the judge and be attentive. I go through the whole thing about their appearance. I will, if they haven't been to court before, I will send them a picture of the judge and go, this is your judge. If it's a man client and a man judge, I will say, look as much like the judge as you can. Same thing if it's a woman. Dress, very conservatively, very professionally. Don't wear shorts, don't wear flip-flops, and come in and realize that, as Rebecca said, court is theater, and whoever puts on the best show is the one that wins the circus prize. So you got to put on this show and bring forward this storyline and tell this story, which is your side of the case. And it has to be believable, and it has to be intelligent, and it has to be, conceivable and all that if you want to get what you want. And, I do very similar preparations to what Rebecca said, but I think a lot of it is client appearance and client management. What are their mannerisms that are going to come up during the trial? Are they going to sit there and pick their fingernails and lean back in the seat and put their fingers in their mouths and all that stuff? I told them, I go, you sit up, you sit up like you were in school in first grade, no leaning back in the chair, both hands on the table, pen in one hand all the time. And if you see me, if I'm looking at the judge or I'm writing on the pad, don't bother me. wait until I'm not looking at the judge or not writing on the pad to pass me your questions.
Yeah, and I think so. I've had cases where we have, you know, when you're going to be examining your own client, you can prepare a script. I think most of us prepare a script so we run through it with our clients, right? We bring them in and we go through because we know what we think the answer is, but we want to make sure that they're telling us the answer that we think they're gonna give. It doesn't mean they're always gonna do it. Sometimes they have their story and they want to tell it and it doesn't matter, but you do your best. You know, I had a friend go to court once with her client and the judge pulled her aside and was like, you know, and you know, he was wearing flip-flops and he like smelled like weed. And so she said something to him and he's like, but they're Prada sandals. And it's like, no, flip-flops are flip-flops. And you will see, we're going to see if the courts reopen and you guys are able to go to court, but it is astounding what people wear to court. It is astounding the directions that you actually have to give your clients who seem like otherwise function very well in society, not always necessarily know, you know, how to behave in court. And, you know, sometimes your clients are going to cry in court. That's okay. The judges are human. We don't have juries. We have judges. They're human. They're going to feel that if there's genuine crying from your client. And, you know, you want to make sure that your client understands the procedure, because if your client doesn't understand like who gets to go first and what order things are going to happen, you're going to have a client who's going to go, Judge, can I say something? And then you're the jerk because the judge is going to go, yeah. And then you're the jerk if you're like, no, right? It seems like you have something that you want to hide, but you have no idea like what it is that your client feels so compelled to say. And they're either about to like give away the farm or say something really incriminating. But I can guarantee you that 99% of the time, whatever it is they want to say, you don't want them to be saying it. So you need to make sure they understand the rules, that if they want to go to the bathroom, they can't just get up and leave. I had a judge go nuts. I was in the middle of actually testifying. I was the lawyer in the family case. This was the adoption case. I was testifying in it. The interpreter for mom goes to get up to like use the bathroom. The judge understandably went bananas. And like, we had to like stop until she came back. And then he gave this like big lecture about how you can't just like get up and leave. So you need to make sure your client understands all of that. But really, most of the preparation is for you, is to make sure that like, you know what all your questions are going to be, that your client understands the expectations, your client understands what the order is in court, that there's probably going to be opening statements. Sometimes judges go, wow, let's skip opening statements. Let's just like get right to it. And you kind of got to like go with the flow, that there's going to be a direct, there's going to be a cross, that they can't lose their temper on cross-examination. But really you're almost like the quarterback of the team when you are in a hearing. And it's like everything should kind of be going in like slow motion for you as you are asking questions and fielding objections and getting exhibits in. And you just have to get comfortable with that. But what you don't want is your client to sort of like work against you. I had a client once who, the nicest guy in the world, oh, he was so nice. And he had put a disability entry on his financial affidavit. He had disability insurance. And the other side was doing a very good job of going through every single item on his financial affidavit. Why? Because we were looking for alimony. He was a lawyer, but he was like a baby lawyer, and she was like a very accomplished doctor who like had invented stuff. And so they were really nitpicking every little thing to try to get the alimony amount down, right? And one of them was disability insurance. And I'm thinking like, well, I know the answer as to why he has disability insurance. And he just like froze and couldn't give it. And then when he comes, the examination is over and he comes and sits next to me and he's like, should I have mentioned that I'm blind in one eye and I might be going blind in my other eye, so I have disability insurance in case I go 100% blind? And it's like, yeah, that's probably something you should have mentioned when they were asking you about it. And it's unclear why you didn't, given that we talked about it like yesterday when we met. So it's, you know, there's going to be frustrations. You have to keep your cool as well. You don't want your client to feel like if it's going south, you don't want the client to get from you that it's going south. And a lot of times a judge will say in a hearing, and you need to prepare your client for this, right? I don't know if this is, I'm sure this has actually happened to both of you, where a judge says, why don't you go outside and try to settle the case, right? You're all amped up, ready. Has that happened to both of you where the judge is like, go outside. You can use my chambers. I'll leave, right?
Yes, some judges are like, have you guys talked about resolving any of these issues? And if you tell a judge no, or kind of, sort of, you give them any leeway where you haven't talked about it, I've seen judges send people outside to discuss the case and see what they can solve. And he says, when you have a resolution to something, come back.
All
Oh
the
yeah,
time.
you see,
All the time.
Your
You know,
experience
see
as
that.
well?
I want to speak just for a couple minutes, if I can, Kira, about the traumatized client, because I think that's important.
Yes.
It changes your preparation. It is not unlikely that at some point in everyone's career, they'll have a client who has been traumatized, certainly in family law, by the other side, whether that's through violence or through words or through some other abuse of some kind. It's not unusual, right? You will encounter it. And the traumatized client behaves oftentimes in a different manner from your non-traumatized client. And the hallmark of that is, while most people, when they're in an adrenaline situation, will respond with fight or flight. And so you'll see sometimes a lot of aggression on cross-examination, because that's that fight response. A traumatized client has a third response when they're in a high stress situation with the person who has traumatized them. And that response is one of freeze. And it's a client who just shuts down and can't answer questions. It's one thing if your client is shedding a couple of tears and it's an emotional moment. It's another thing if your client cannot speak or is so overcome by tears and emotion that they can no longer be their best advocate. And it's really important for you as an attorney to recognize that and to try to get ahead of that and recognize that before you're in front of the judge, and make such accommodations as you can. And there's several strategies for that. One of those strategies is to think to yourself, this is not a case that can go in front of the judge. I will not get a good result for my client. We need to settle at all costs, because anything we get in settlement negotiations is going to be better than what the judge gives us, because my client is going to just wreck this case. So that's one. I'm sorry if I'm keeping you up. So that's one. That's one strategy. Another strategy.
All day. I'm like texting about like monitored exchanges and staggered exchanges because there's no school. Like I'm getting all these emergency texts through this. I'm sorry, I didn't mean to yawn. I'm sorry. It's not boring.
But the second strategy that you might consider is one of bringing an advocate in for your client during the time that they're in front of the judge. That could be a best friend who isn't going to testify. That could be a mental health professional who isn't going to testify, but just someone who can just be there, that they can turn around and look at, who they can make eye contact with if they're on the stand and they're really nervous. And that may, or it could be a service animal, right? It can really be a lot of choices. In the Fifth Circuit, service animals. In the Fifth Circuit, they have service dogs that go from courtroom to courtroom, and it's the nicest thing. I've met the dogs, they're amazing. And they really serve a really important function for traumatized clients. So you have to just think about that as well. If you've got issues of domestic violence or drug abuse in your case, or if you've got a client who tells you that she's had a really bad past with abusive parents or incarceration, right? You may be looking at a client who's got some trauma that you may need to address when you think about how to prepare them for being in front of the judge.
I think those are great tips. So we've gone over, yesterday we did how do you prepare yourself to take a deposition. Today it's how do you get your client ready for that deposition? How do you get your client ready for court? How do you get yourself and your client ready for mediation? And very quickly, I just want to talk about how do you get your client ready to meet with a guardian ad litem or to go to a parent coordinator, because all three of us have had cases with guardian ad litem. Both Rebecca and I have served numerous times as guardian ad litem. Rebecca was my mentor. She actually taught me how to be a guardian. And the way that Patrick and I actually met was I was a guardian on his case. And so, my short answer on how do you prep your clients to meet with the guardian is I have them meet with Rebecca, and I have her do a mock interview with my client and give feedback. And if the client has recently set up a new household, I will have Rebecca go to the house and do a home visit, because the guardian ad litem is going to. And, you know, sometimes you don't really see what's around you until there's another set of eyes on it. And you go, oh, maybe that's not the place for, you know, my ammunition and drugs. So
I've had that.
so I'm gonna have Patrick talk very quickly about what do you do when a guardian ad litem has been appointed in your case? How do you prep your client for that meeting? And then I'll have Rebecca talk about it.
I go with them. I go over, you know, what is a guardian ad litem? What do they do in cases? How can the guardian ad litem be beneficial to your case? And how can the guardian ad litem be detrimental to your case? And I'll tell them, I go, when you meet with the guardian ad litem, the first thing is probably going to be the in-office consultation, and there may be home visits later. When you go in to meet with that guardian ad litem, the guardian ad litem, like the other attorney, is not your friend, but don't be aggressive with the guardian ad litem. Explain your position to the guardian ad litem and, you know, what you're looking for in your case and why you're looking for it, and be very upfront and honest with them. And, you know, I do a lot of cases with people that have pretty significant mental health issues. And I tell them, I go, listen, make sure you tell the guardian that. Make sure you tell the guardian what you're dealing with on issues outside of this case that may affect your case. But yeah, you just give them a brief rundown, try to get them comfortable. And, you know, I think once they, at least the clients I've had, once they understand what the guardian's role is and what the guardian can do, they're a lot more comfortable with it than, you know, their first thought maybe, you know, this third person's coming in to evaluate me for my fitness as a parent, which isn't necessarily true.
I remind the clients that the purpose of a guardian ad litem is to look out for the best interests of the children. So I try to keep the client centered on best interests of your child, which may or may not be on your best interest, but you know that the guardian is team child. So that kind of helps them remember that they're not an agent of the state, they're not an agent of the other side, that they're there to help the child. I also counsel my clients with respect to some sort of hot button or pitfalls that people fall into. So I'll tell the client, don't you dare say anything negative about the other parent. Right? Let the other parent dig themselves their own hole. That kind of thing, because, you know, guardians are very much have their ears open for what's the negative stuff that they're going to talk about each other. What's, you know, what's happening on Facebook or Instagram or any of that. And so how are you going to shut that down, take that away, because your guardian wants to see that you, my client, are doing your very best to work well with your other parent. And so you have to like play that up.
Right. It's you know, you're not going to have a guardian in every case that has parenting issues, but if you have a guardian, it means like something big has happened, that a party has sought a guardian or the judge has decided on his or her own that you need a guardian ad litem. And a lot of power is then vested with the guardian to make recommendations to the court, to make recommendations to the parent. Sometimes you won't even get to court because the guardian is going to, you know, say, well, this is what, if you guys went to court on this issue, this is what I'd recommend. And you kind of have to say like, well, is that something that I want to impeach the guardian about? You know, I had a guardian once say, well, I'm going to recommend this to the judge. And I was like, oh, like, I don't want that. So I just kind of spent a lot of time advocating why I thought, in a very nice way, why I thought she was wrong and what other solutions I thought would work. And she ultimately did change her position before court. I did pull her off where she was. But it was obviously upsetting to the other side. But a lot of the times you're like, you can say to your client, listen, like, can you live with that? We're not going to go to court about that issue, right? Because this is what the guardian's going to recommend. And it's not going to look great if you have a guardian that the judge has chosen, that the first time you go back in front of the judge, you're like, well, I don't agree with what the guardian has recommended. So you can do work on the guardian, but it's a little bit tougher to kind of like try to tear the guardian a new one once they're actually on the stand. Judges are very appreciative to guardian ad litems and the work that they do. And so the last thing you want to do is be disrespectful to the guardian or have your client be disrespectful to the guardian. And so you want to make sure your client understands the role of the guardian and what information they might need. I'll sometimes say to a client, like, prepare your narrative. Like, let me see it, but prepare a narrative so that you're not just telling this whole story to the guardian, but they have the story in printed form, because they might be doing a report in 2 weeks, they might be doing a report in 6 months or 9 months, and you want them to be able to go back and be like, oh, this is everything this person told me, and wow, look, this issue has remained a thread throughout the case. They said that the other person did X, Y, and Z, and look, this has continued to be a problem, and so I, the guardian, need to make a recommendation to deal with that. But I know that you guys have done your reports, or you're working on your reports, kind of depending on when you watch this video versus when you did your guardian ad litem reports. But part of your work as your guardian and doing that interim report was getting that questionnaire done, which is that's something where if a guardian does give your client a questionnaire, you need to let them answer it. You can help refine some of the answers. You can't fill it out for your client, but you can help refine. And you guys have done interviews. You've interviewed the parents to formulate those interim recommendations. And so you as the lawyer had to prepare yourself as the client to do that. And so basically that's it. This was take 2. I think I'll add a stuffed animal each time we do another video until I run out, but I've got a lot. So I think I have more than I know. You win them at the youth fair. I'm very good at youth fair games. And then what are you gonna, you can't displace a stuffed animal.
You can donate them to the Children's Hospital for children who
donate
might
them to the courthouse too.
I mean, I will see who's willing to leave the nest and go live somewhere. We'll see. But and it's something in your What I Learned memo. You're welcome to mention how many stuffed animals to prove to me that you have been watching. How many stuffed animals and what kinds because the students have to do What I Learned memos from these videos. And so it'll be interesting to see if they made it to the end and who takes the guidance, and if they start texting each other like, there was a polar bear and a tiger.
You should totally remove or rearrange in the last 5 minutes.
Right. This is still on video. We're still, but we'll see if any of them even see this, right? So I want to thank both of you so much. We're asking a lot from our students, but also these are 2 lawyers who have their own firms with employees. This is a really tough time for lawyers because the courts are closed except for mission critical hearings. But we are trying to continue to represent our clients. We're trying to all do it remotely. We're trying to have our staff either one at a time in the office with lots of sanitation, or trying to get staff members to work remotely. We're trying to make sure that everybody stays employed, that all bills are paid, that every payroll is being made, that there's no shortage of services. It's a very stressful time. And so any lawyers who in the midst of all of this say, you know what, it's virtual, I'm not even getting my brownie that I normally get, but I'm willing to jump online to give guidance to your students, I could not be more thankful to. So I want to thank Patrick. I want to thank Rebecca. What?
Always happy to do it.
Thank you. So I'm gonna press end meeting because I'm not sure if another way to do it. Okay. Bye everybody.